Hello and welcome to part 2 of our employment law update. Today is Wednesday the 8th of July and this was intended to be a live session, but unfortunately, as you're fully aware of the difficulties that you're having when you're wanting to log in this morning, that didn't happen. But hopefully you'll still find this on-demand video useful to you and hopefully enjoyable and informative too, we hope. So as we move on to the next part of the session, so obviously part 1, if you haven't seen it already, deals with the flexible furlough scheme from the 1st of July and goes into quite a bit of detail on that, because got quite a lot of information to cover, which is quite surprising, seeing as you might think that it's only a little change to the scheme to allow people to be working part-time, but quite some fundamental issues that employers are needing to address as we go forward between now and the end of October with that scheme. But anyway, I trust you found that one helpful. Now we are moving on to a number of other topics. So first of all, we're going to be dealing with the arrangements for employees when they are returning to work. So it's how you ensure a safe return for your employees, because now hopefully we are at that stage where your business is now beginning to ramp up a little bit, and particularly for those who are working in the retail sector, then we are seeing the opening of shops and also the relaxation of our traveling rules, which enable people to travel to work and also to go shopping, and so it's beginning to get the economy moving a bit more. Appreciate that the hospitality sector is now still a little way behind, but we've got to start making plans now in order to plan over the next weeks and months, making sure that we're able to return employees to work on a safe basis, particularly for those who have been furloughed and are now coming back to work on a part-time basis, albeit that they might still have some furlough as well. So what are your obligations? What do you need to do? Now, obviously, there is an awful lot of legislation that you have to comply with. Now, this isn't a health and safety webinar. I don't profess in any way to be a health and safety expert, but it's quite right and appropriate for me to just let you know what all of the legislation that covers your health and safety obligations are. For those of you who have a specialist resource within your organization in relation to health and safety, then of course you'll be wanting to liaise with them, and certainly the work that HR and health and safety will be doing together in planning for the safe return of employees to work during this period of time is going to be fundamental to its success. But just having a look at the real principles that we've got here, obviously we've got the Health and Safety at Work Act 1974, which gives the fundamental principle of the duty of care of the employer to the employee. We've also got a lot of detailed government guidance. Now, this, and when I say detailed government guidance, this is, I should have clarified on the slide, but I haven't done so. This is in specific regard to the COVID-19 situation. And so on the 11th of May, the government published 8 sector-specific pieces of guidance in relation to ensuring employees' health and safety at work. And those covered the construction sectors, factories, laboratories, offices, working in other people's homes, restaurants offering takeaways, shops and branches, and also vehicles as well. They've extended that guidance as well. There's further guidance which has been published on the 23rd of June, which also covers close contact services, heritage locations, hotels and other guest accommodation, and the visitor economy. Now, we've got to keep a particular close eye on these bits of guidance. And the reason that I say that is because along with everything else, they're changing all of the time. I mean, just to give you an example, I'm just going to read from my notes here for a second, just to give you all of these dates. So what we've got is, since the publication of those 8 pieces of guidance on the 11th of May, they have been updated on the 19th of May, on the 25th of May, on the 29th of May, and then again on the 14th of June, the 15th of June, the 23rd of June, and the 24th of June. So if we thought that the furlough guidance was being updated quite regularly, you can see that actually the health and safety guidance is being updated very, very frequently indeed. And of course, we had the additional pieces of guidance for those other 4 sectors that were also published on the 23rd of June. So it really is a case of watch this space. So please, if to whatever extent you are involved in ensuring the health and safety of employees as they're returning for work, go to those pages on the government website where those pieces of guidance are and keep a close eye on them, okay? Because they are changing, and they're changing quite frequently and regularly, okay? So, sorry, just going back to the main slide now. So we've covered off the duty of care. We've looked at the guidance that's been published. We've also got management of health and safety at work regulations, which deals specifically with risk assessments and safe systems of work and surveilling health surveillance. We've got their workplace health, safety and welfare regulations 92, which deal particularly with cleaning, ventilation, space for social distancing, one-way routes, toilet and washing facilities. And when I say specifically, that's the impact that it has in these specific circumstances. Obviously the PPE regulations, so PPE is a significant issue at these times, and albeit that will potentially vary from sector to sector. It depends upon the extent to which there is contact obviously with the public, and also the control of substance hazardous to health regulations, prevent exposure to hazards to health, and of course exposure to COVID-19 would be covered by that. So we've got it goes right across all legislative issues, or all legislative obligations, does the issue of COVID-19. So we need to be really quite clear on what our obligations are, what our duties are, and how we're going to address that, and how we're going to put in those safe systems of work. Now, so what are your key steps? What do you have to do in order to meet all of the obligations that you might have under all of those pieces of legislation? Because there's an awful lot there. So in terms of the key steps, so first and foremost, we are still in a situation where every reasonable effort should be taken to enable people to work from home if they can. Okay, so that's the first port of call. And if you can't do that, then of course we've got all of the issues in relation to social distancing and hygiene and PPE and risk assessments and safe systems of work to adhere to. Now, when we look at risk assessment, now unfortunately, and I don't know quite why, but unfortunately the UK government hasn't published a template risk assessment for the COVID pandemic. What happened is that if you go to the government's website, you sort of get caught in a loop where it just directs you back to the normal risk assessment templates. And that's not necessarily the end of the world, but actually it's not particularly helpful, and I think employers could do with a bit more help in this regard. But the Irish government has done so. The Irish government has published a template risk assessment document for this particular situation. So you can either just Google that, or alternatively, if you want to go through my LinkedIn, I certainly did a post on my LinkedIn in relation to that document, and again, because I've name checked a couple of other people so far, I would like to thank Michael Duggan QC for highlighting that to the legal community. He discovered the Irish template, and as I said, it certainly seems, from my unqualified health and safety point of view, it seems to be a very good document to use, albeit that again, I would encourage you to liaise with your your health and safety colleagues in order to ensure that it is appropriate in the circumstances for you. So that deals with doing your risk assessment, and you do need to do one, because of course what you need to be able to show is you need evidence to show that you've met your obligations in relation to the duty of care by undertaking the risk assessment. And that then enables you to establish the safe system of work. And then once you've established that safe system of work, you of course then have to make sure that that is followed and adhered to. So that is by ensuring that you provide the appropriate training to your employees, you've got appropriate signage, you repeat the messages time and time again, and you intervene, the management intervenes when things are either going wrong, so perhaps disciplining employees, warning employees when they are doing things wrong. That might be informally if it's just for minor breaches, and reminding employees about how they should be socially distancing and what PPE they should be wearing, so on and so forth. But alternatively, in more serious cases, it might be disciplinary action, and that would be perfectly reasonable in the circumstances. So that is how we then ensure that we are meeting our obligations. Now, of course, what can then happen is that, or what's bound to happen, is that some employees might still be concerned about attending work. So even where for perhaps, you've communicated where your entry and exit points are, where your additional parking areas are, and bicycle racks, and perhaps leaving seats empty on the company minibus to reduce density, your entry control systems, your one-way flow systems, your alternative methods. Rather than using keypads, you're using non-touch opening for doors, you're leaving not non-essential necessarily, but where there aren't fire doors, you're leaving other doors open so that people aren't needing to touch them. You're wedging those doors open. You're working with other organisations or other people in the local vicinity to make sure that you're sort of staggering arrival times. That at meetings you're only having those people who are absolutely necessary to attend meetings. You're not sharing equipment. You're holding them in well-ventilated rooms. So all of these considerations, which need to form part of your plans to ensure the safe return to work, and communicating that to employees, and of course adhering to all of those guidance documents, or should I say the relevant guidance documents that were highlighted earlier from the government. All of that is going to go a long way to ensuring that you have got a safe system of work. But notwithstanding that safe system of work, can an employee still refuse to come to work? Now, the issue that we've got here really falls within two legal arguments. So we're looking at section 44 of the Employment Rights Act. So this is looking at the issue of where somebody believes that there's a serious and imminent danger to health. And if they make a complaint about that serious and imminent danger to health, and they reasonably believe that there is that serious and imminent danger, then if you were to take action against them, if you were to dismiss them, for example, for refusing to come to work, then that would be an automatically unfair dismissal. And the similar sort of provisions apply in relation to whistleblowing, because of course under section 43B and section 103 capital A afterwards, I missed the capital A, but where somebody makes a disclosure, and in this case it would be about health and safety, no doubt. We talked about making disclosures in terms of legal obligations in terms of the health and safety of children earlier on, but this is about the workplace and ensuring that the duty of care under the Health and Safety of Work Act 1974 is being met and complied with. That again, this is all just about what the individual reasonably believes. So it might be reasonable, and this is where we can get into a bit of a quandary, it might be reasonable for the employee to conclude that there is a serious and imminent danger to health, or that there is a breach of a legal obligation. And it might also be that it's a reasonable instruction by the employer in circumstances where they have complied with all of the government guidance to instruct the employee to return to work. And so therefore we sort of get into this situation of, well, neither the employer and nor the individual is wrong in this situation. So this is going to be an incredibly difficult one to manage, because it's not necessarily the case that you're just simply going to be able to force your reasonable instruction, or should I say take a sanction against the employee who's not complying with this reasonable instruction, because of the protections that will be provided to them under these other pieces of legislation. So under the Employment Rights Act, both in terms of health and safety detriment and also in terms of whistleblowing. So it's going to be really tricky, and so you're going to have to take a very practical approach in these circumstances. You're going to have to talk to employees, you're going to have to try to reassure them, and have to do that on a case-by-case basis. And perhaps where you do have a trade union within your organisation, then try to use them as well to support the messaging and support the steps that you have taken to ensure the safe return of employees to work. But it's going to be a tricky one, but hopefully you're going to be able to deal with it simply by having an effective communication strategy in relation to the steps that you're taking. And if you do that, then hopefully you'll be able to address a lot of these issues before they come to the fore, because you'll be able to reassure employees at an early stage. So that's dealing with the arrangements of the safety of arrangements for people returning to work. So moving on now, so data protection. I know that I missed this off from the original agenda that I introduced at the beginning of the session, but it was always intended that we were going to be talking about data protection and working from home, because of course one of the issues that many employers have faced in relation to people working from home is sort of twofold. First of all, it's, well, are our employees actually working, and to what extent can we monitor them to provide us with the comfort that they are working, and say particular in instances where they have also got the competition for their attention because of childcare. So we've got that point. We've also got the other point, which is, how does the employer ensure that all of their data is being sufficiently protected? So those are the two key points that we're going to have a look at in this section. So first of all, in relation to the reason why you would want to potentially monitor employees. So this isn't necessarily or shouldn't necessarily be looked at in an entirely negative Big Brother kind of way, because of course we've all heard about the impact that working from home is having on people's mental health. And it's quite a common trait that when people are working from home, that they don't take the sufficient breaks. There aren't the water cooler moments for people to be having a chat with their colleagues. There aren't those natural breaks, and so people can burn themselves out. It can affect their well-being. Perhaps it isn't quite so easy for them to delegate because they can't just turn to their colleague next to them. Or alternatively, their colleague isn't noticing that they're particularly stressed and isn't offering to take a couple of bits of work off them. So all of that in relation to the working from home circumstances can have an effect on people. And of course, often people just tend to work longer hours. They're not commuting. They might not take the lunch hours that they would otherwise take, and so they end up just working longer hours, and that having an effect on their well-being. So then what we've got to have a look at is then our ways in which we can monitor that, and how and why we would monitor that. So the forms of monitoring there, as you can see, so we've got self-reporting, we've got just intermittent catch-up calls with the manager. So that's the management interaction. And then we can get into some more, the more intrusive, so monitoring the number of emails that that are going in and out of the system, which you might do in any event, but you might just have greater focus on that information because of the current circumstances. And the same goes for internet use and for telephone use. Obviously, you have to make sure that all of this is provided for within your privacy statements and also within your data protection policy. But hopefully that is already there. Now, there are other reasons why you would want to be monitoring employees and monitoring the communications. One of the things that has certainly come to the fore in terms of the amount that people are working from home and the different forms of communication that we're now using. So the use of Zoom, the use of instant messaging, the use of text messaging, the use of WhatsApp to communicate with colleagues has increased significantly. And so now the opportunity for other avenues, other methods of harassment to take place has also increased exponentially. Because of course now what we've got is, rather than comments necessarily being made within a work environment which might be witnessed by people, we've now perhaps got video calls, which of course now perhaps nobody is overhearing, and perhaps comments are being made. And so we've got to be aware of these changes, and that might be one of the reasons why we would also be wanting to monitor, to make sure that there aren't any harassment issues occurring. But again, we need to go back to the principles of what the legislation says. And when we have a look at what the legislation says, here is the data protection legislative environment. So as you can see, there's quite a lot there. We've got, of course, the Data Protection Act 2018 implementing the GDPR. So we've got the Investigatory Powers Act, we've got interception of communications, and we've also got a right to privacy, which is something that I'm going to now talk about, because one of the other things that we've seen a little bit of, I mean, certainly there's been reports in the press, and there are systems that are being sold to employers, such as Seek and I think it's Sneak and Interguard. Well, I mean the actual title of the software, Sneak, I think says it all, doesn't it? And what this software does is it monitors. It can be installed on the individual's laptops whilst they're working from home, and it monitors the keystrokes. It will take screenshots of what the employee is doing. It can even use the camera on the individual's laptop to take a photo of them to check that they're sat by their desk. And even it goes as far as having a facility to essentially have not so much a wall of shame, but a picture wall. And so what it will do, it will take pictures of all of the employees, say every 5 or 10 minutes, and then it publishes them for everyone to see. Now clearly that has got significant data protection issues attached to it. And so if you are going to go down this route, and it's not certainly something that I would necessarily be recommending, but I'm not saying that you can't do it. What you would have to do is go off to do your data protection impact assessment. Now, we've got a template data protection impact assessment document for you to use, but essentially what that document does is it enables you to pull together all of the options that you have and all of your business reasons for why you would be undertaking this level of monitoring, and whether there are less intrusive ways of doing it. And of course, if you are going to be doing it, then what you must do is tell employees that you're doing it. Because if you're doing covert monitoring of this type, then that is going to fundamentally impact on as you see, the right to privacy that an employee has. It can get to the duty of trust and confidence in the relationship, enabling an employee to resign and bring a constructive unfair dismissal claim, and potentially even discrimination claims as well. Because, say for example, if I was being monitored by my employer in that way, and then it just so happened that during one of my during one of my breaks, I'm then on my computer and I'm perhaps, I don't know, ordering a repeat prescription from my GP. That then, if my employer was to then have a screenshot of that, they would immediately know what medication that I'm receiving. They would be able to work out what condition, what medical condition I'm suffering of. And clearly, if that's something that I didn't want to disclose and it wasn't necessary for me to disclose, that would be a fundamental breach of my privacy. And that would leave the employer open, as I said, to constructive unfair dismissal claims, discrimination claims, and also, of course, complaints to the Information Commissioner. And complaints to the Information Commissioner can come with fines of up to 4% of global turnover. So I think it's something that you need to have a serious think about before you're going to do it. If you are going to do it, do your data protection impact assessment and make sure you communicate properly with employees about what it is that you are doing. And if you do that, then certainly that's then going to begin to go some way to meeting your obligations under the GDPR and the right to privacy that we've got. And then, of course, we're having a look at what the data risks are. So rather than actually, obviously that was looking at monitoring and the pros and cons of monitoring and what you need to do from a legal perspective in order to be able to monitor. But what we've also got from the employer's point of view is, of course, everyone